This is Hapco Philadelphia. We're doing another Zoom meeting to discuss the changes and the new developments with the eviction rulings in Philadelphia. And we have Paul Cohen and Janelle Maricini basically hosting the call and giving us their insight on what changed and how we can implement all the new rules with our individual properties or portfolios that we have. Right now, what we want to do is basically do a session of a back and forth between the three of us, or possibly maybe you two can do it or whatever, and basically just go over the basic steps that involve starting an eviction. And I'll play the person that doesn't quite understand the process as a new landlord. And my first question is, assuming I have a license, forget the term, the certificate that you get online that says your rental suitability.
Mm-hmm. It's a big assumption.
Assuming I have those in place, and regardless of when I got them, because that's a whole nother conversation, and I want to start an eviction process for a tenant, and I approach Hapco about doing an eviction. The new first step is mediation. Is that the answer?
So the first step is to make sure that you're in compliance with the lead paint laws, which just went into effect on October the 1st. And that's going to be one of the things that I'm going to discuss in our seminar this morning. So you need to make sure that you're in compliance with the lead paint seminar. I'm not going to go into that right at this moment, because that's going to be part of the seminar. I'm going to go into that in depth. So you need the rental license, certificate of rental suitability, and you need to have your lead paint certification done. Assume you have a property that was built prior to March of 1978.
Correct. And so your license, and your lease, and then probably a ledger. Those are usually the 5 things that you're going to need.
And can you remind us all what the ledger is going to include?
Rent that is due, late fees that might be due, any utilities that may be due.
Basically, the reasons that are requiring me, or not requiring me, that are making me come to eviction court, possibly.
Well, so correct. I'm assuming it's a non-payment of rent case. If it's for something other than non-payment of rent, then that ledger might not be necessary.
Okay. And then the next step after, well, my question is, I'll do it this way. The mediation between myself and the tenant to initially provide them the possibility of giving them another chance to resolve this that's a question.
Okay, so the first thing we have to determine is whether or not it's a non-payment of rent case. It's a case for breach of conditions of the lease agreement, or it's a case for termination of the term. Term of the lease is ended. Let's assume to start that it's a non-payment of rent case, because that's the most difficult one and it's the most likely. On a non-payment of rent case, before you can proceed with an eviction, you have to file or send out to the tenant a hardship repayment notice.
Correct.
That hardship repayment notice, which we'll go through in a little more depth during the seminar, gives the tenant basically 30 days to come up with a plan to pay back the money. They can pay back the money over a period of 9 months.
So assuming today is November 23rd, I just mentally said to myself, I have all those things in place. I now, before I even go to court, have to initially send out the non-payment, or not the non-payment, the ability for them to set up a payment plan prior to me even going to court.
Yeah, it's called the hardship repayment notice. And in that hardship repayment notice, you also have to notify them of their rights that they have. A sample notice is online on the Hapco website. So you can go on the Hapco website and get a copy of that. That has to go out to the tenant first. It's the very first thing you need to do. Okay?
Yep.
Then after you send that notice, you wait 30 days. You wait for the response. So if the tenant wants to enter into a repayment agreement, then you enter into the repayment agreement with them, and then you see if they follow that. Assuming you get no response at the end of the 30 days, then you should file with the diversionary program.
And that's the mediation you're referring to.
Now, what happens if they respond to the hardship repayment notice and say, whatever they say, they want to come up with a plan, but I don't like their plan?
So they have an absolute legal right to force you to agree to their plan if it's to pay over a 9-month period.
Okay.
So it's either a 9-month period or a 30% of the monthly rent, whichever is less.
Okay.
Plus ongoing rent. They do have to pay their ongoing rent as well.
Correct.
So let me ask a dummy question, Paul. What happens if they enter into one of these agreements and they default on the agreement? Do you still have to go to the diversionary program?
That's a great question.
Maybe it's not a dummy question.
Yes.
Here's a piggyback off of that. Today, again, I'm just use today's date. I send it, and 30 days from now is December 23rd. They agree. They start the 9 months. On January 1st, I don't get the ongoing rent payment. What happens then?
Then you can proceed with an eviction complaint.
Okay.
Okay, so they, as Janelle had mentioned, they have to pay under the payment plan, and then and in addition, they have to pay the ongoing monthly rent. So if they either miss 4 payments under the plan or they don't pay the ongoing rent, then you can proceed with the eviction complaint.
Paul, someone just wrote in, is the hardship repayment notice only for rents due between March and August, or has that changed? My tenant is delinquent starting in October.
That's going to be part of the seminar this morning on the new law that's going into effect shortly. So I'll get into that in a second. But the short answer to your question is it's going to be March 1st through December 31st. But I'll go through that for detail.
There's bills that have been introduced. Hang tight.
This morning, we're still doing a quick session just to go over the basic steps. Paul will go into more detail on some of the things that have changed with the steps, but we're just kind of making sure people are actually aware of how an eviction process is actually supposed to go, in theory, at least. So.
Yeah. So right now, as we're going through this, just to recap, you have to, if you want to file an eviction for non-payment of rent, the very first thing that you need to do is send out the hardship repayment notice. That gives them 30 days. After the 30 days are up, then you file with the diversionary program. Assuming that under the diversionary program, you can get a hearing in diversion within 30 days, then you have to wait those 30 days as well, go to the diversionary or mediation program, see what happens at the end of that. And then if you're not happy with the result, then you can file a landlord and tenant complaint. Long process. We understand. As I tell everyone, don't shoot the messenger. Janelle and I are just the messengers here. We have
thought all of this, guys. We have on your behalf, but we didn't win.
And by the way,
when did hardship repayment notice regulations start? It started when we were able to start doing the filings, which was the end of the summer. However, it's retroactive, so it covers the period starting in March of 2020.
Okay. Now that we've gotten past the hardship repayment notice, for whatever reason, the tenant still didn't comply, and we get to the next step of actually starting the actual eviction, we submit paperwork to Hapco, and that step, well, assuming, obviously Hapco does most of the steps for us, but can we start with that process when we file everything with the courts?
So at the initial step prior to filing the hardship repayment notice, everything should be sent to Hapco at that point in time. So all the information, as Janelle mentioned, the tenant ledger should be sent, and whatever other information with regard to the tenant, the lease, the license, the certificate of rental suitability, the lead paint certification, all the documents that you normally send to Hapco for an eviction complaint, they should be sent prior to the hardship repayment notice being sent to the tenant. So that should all be done up front. So now Hapco has all that. They can go ahead and proceed, send it to the attorney to go ahead and send the hardship repayment notice out. Then if they don't comply, there's no additional information that would have to be sent. Right away, it can start with the diversionary program. And then if compliance isn't done with that, then the eviction complaint can be started.
In the court.
And good luck on getting a hearing date. We'll talk about that too.
So just a couple quick questions I'm seeing, Paul, that kind of apply to this. Somebody was saying, should the notice to quit go out at the same time as the original hardship repayment notice, or must you wait until after the diversionary program?
They're basically one and the same thing.
Same thing. Yeah. Did you draft the one that's on the Hapco site, Paul?
I believe so, yes.
Because if it is the same one, Paul kind of combine the notice to quit and the hardship repayment notice so that you only have to send one. And then someone's asking about what happens if you filed eviction prior to the regs. So if you had a case that was supposed to be heard but didn't get heard because of COVID, those cases should already have been coming back up. They've been being heard since September. Some of the judges are requiring the hardship payment notices to go out regardless of if it was prior to the regs or not. So our suggestion is send them out preemptively before you get to court, because depending on what judge you get, they're requiring them, even though they shouldn't be. But if you want any ongoing rent for March or later, so let's say they owed you January and February and you filed in February. If they now owe anything from March through now, you're not going to be able to get that rent. The judges are shutting that down if you didn't send that hardship repayment notice. So I would send that out.
Yeah, any old cases that you have, if you haven't sent a hardship repayment notice, make sure that goes out, because you're not going to be able to collect that rent otherwise. Okay.
Okay.
All right. So we want to, I guess, move forward.
Yeah. Do you want to stay on this, Paul? We might as well and go through all the new bills on this before you move into lead.
Sure.
Okay.
Okay. So the City Council has introduced and passed an extension of the Emergency Housing Protection Act bills, two of the bills. So the two that they have extended deal with, number one, the hardship repayment notice that we're talking about now. So under the original act, the hardship repayment notice ended as of August the 31st. That period has now been extended through December the 31st. So the definition of COVID-19 financial hardship is now the period from March the 1st through December the 31st. Prior to that extension, it was March the 1st through August the 31st. There's a timeline, by the way, the mayor hasn't signed the bill yet, but it's about to happen any day now. Prior to the extension, there was a lag because as of September 1st, you could start filing complaints for non-payment of rent, and the tenant couldn't claim that that was part of a hardship period. That gap between September 1st and the date this new law goes into effect is covered under the new law. It's basically retroactive. So for your purposes, what you need to think about is the COVID-19 financial hardship period is from March the 1st through December the 31st. So if the tenant has some type of a hardship due to COVID-19 where they are unable to pay the rent, then that rent that's accumulated between March 1st and December the 31st can now be put into a plan and paid out to the landlord over a 9-month period. So in answer to Brian's question is, suppose you don't agree with it, you don't like it. As they say in the law, I'll try and be tough noogies. How's that? Trying to be politically correct here.
Oh, well, is the answer.
Oh. Yeah, much are forced to agree to it. So it's the lesser of not a 9-month payment plan for the money that's owed, or 30% of 1 month's rent, whichever is less. That's what the tenant has to pay. And that has to be done monthly. And as we said before, they also have to pay the ongoing rent. Okay, so that's one of the things that's extended. I just a quick popped up about late fees. The second bill that's getting passed deals with the late fee issues. So it now says that you can't charge late fees for the period from March the 1st through December the 31st as well. So you basically can't charge it during the COVID-19 financial hardship. And then that's been extended to the period through the end of April. It was originally going to be for 9 months. After that, there was an amendment. It looks like it's now only going to be through, not only, now going to be through the end of April. Or end of May. What's 9 months from
May.
January, March, April.
May.
May. Thank you. Yes.
I had already done the math.
Yes. So through the end of May, you won't be able to charge late charges on, assuming that the person had a COVID-19 financial hardship, which means that they probably didn't pay rent but sometime between March and end of December. If come February they haven't paid rent and had nothing to do with the COVID-19 financial hardship period, then yes, you can charge late charges. But my guess is when you go to court, nobody knows the answer to this because obviously we haven't been there yet. The judges aren't going to give you late charges.
Someone just in here, just what type of proof does the tenant have to provide to show his or her hardship? They're requiring very little right now. They say that I had a hardship, that's about it. So at this point, I would just bank on no late fees through April.
Yeah, and the new also includes the CDC hardship notice. So if they've given you that CDC hardship,
the affidavit.
Yes, thank you. Couldn't think of the word. They give you the CDC affidavit, then that will comply with the hardship qualifications. And as Janelle was saying, it's basically anything. You're not gonna win on those cases in Philadelphia, unfortunately. So if the person's claiming a hardship, they haven't paid the rent, they're gonna qualify. You know, we can argue it in court, assuming you're able to get to court at some point in time, but most likely the judges are going to lean in favor of the tenants.
Yeah, I understand, guys. They're still only hearing 6 cases every 45 minutes down in Philadelphia because of social distancing requirements. So the courts are completely backed up. As of right now, we had one case that was just filed that didn't get a court hearing date for 6 months. So you're not seeing courtrooms anytime soon. They have to deal with the backlog of cases that weren't heard between March and August 1st. And they're only doing them 6 every 45 minutes. And then they got to deal with all the cases that started getting filed as of September through now, tacked onto the end of that. So if you file now, you're looking somewhere mid next year to have a hearing date.
Yeah, I think they're giving out dates sometime in March right now. But before you can file, as we said before, you first have to send out the hardship repayment notice. You got to go through the diversionary program. By the time all that happens, you're 2 months from now. There's going to be a huge onslaught of cases coming in January. Don't even want to begin to predict what kind of court dates you're going to get. But like Janelle said, it's going to be well into 2021 before you're getting into court, unfortunately. Okay, one of the things that they tried to do in City Council was to have a moratorium on eviction filings through the end of December. That did not go through.
Nobody was more surprised than us.
You currently can file landlord and tenant cases provided you've gone through the hardship repayment notice and diversionary program. Keep in mind, those programs are for non-payment of rent cases. You breach a condition, termination of the term, you can file without going through those notice periods. Okay, so those cases can be filed. You're not going to get a hearing date until March, April of next year. Okay. Does that make sense?
Oh, if someone's asking about evictions prior to COVID, as of right now, there is a moratorium on lockouts. Lockouts are not happening because of the COVID crisis. They don't want homelessness. That's through, did they pass that through the end of the year now, Paul?
Yes, that's through the end of December.
Yeah. So anybody who had evictions prior to COVID, they're being delayed till January as of right now. Our hope is once the vaccines start rolling out, they'll start allowing lockouts again to start happening. We're not sure if that'll be right away in January again or if they'll extend it again. But as of right now, no lockouts.
The guess is the way things are going that December 31st date's going to be extended at least one additional time. That would be our guess. I stopped predicting or tried to stop predicting what's going to happen. And by the way, I forgot to give a quick disclaimer at the beginning of this. Whatever information we tell you is only good as of today. I was going to say this hour.
As of 10 a.m.
Things just change so quickly. So it's hard to predict exactly what's going to happen into the future. So whatever information you're getting is good through today. Check the Hapco website for additional information. We try and keep it as up to date as we can. We're doing pretty good with it. It's very, very difficult to get it up to the minute. I'm trying to get it. We're trying to get it up to the hour and hopefully up to the day.
We taught a seminar one time, and 20 minutes later, the law changed. And 20 minutes after our seminar ended, so we called each other and started laughing at that point. So we're doing as best we can, keeping you guys up to date.
Yeah, and during that seminar, we predicted that it wouldn't change.
Yeah, and then it did.
Yeah, go figure. Okay, so that gets you up to date with the new bills that are being passed, and you know about the extension on no lockouts taking place. Next, I want to talk real quick about rental assistance. So if rental assistance was applied for, that date has passed now, so you can no longer apply for rental assistance. It's unfortunate. I've been telling everyone, get your applications in as quickly as possible. Try and get that money. It's money that's appropriated through the CARES Act. It's not city money. It's CARES Act federal funding. It's available. Use it. Now, the city has reappropriated CARES Act money to be able to go to cases where the tenant has filed the application for the rental assistance, but the landlord hasn't filed for the rental assistance. But the landlord and the tenant have to apply. Okay, so where the tenant has applied and you as a landlord have not, my suggestion to you is get your application in as soon as possible, because there's now money available for you. It's up to $1,500 a month for 6 months, $9,000, basically free money. You're not waiving any of the back money.
Yeah, they changed that.
It's a great program. Get whatever you can get. So if your tenants applied for it, I suggest you get your application in as soon as possible. It's really good. There's additional money there for you.
The only thing is you are not allowed to file for an eviction for 60 days after the last date the payment is received by that money. But for right now, you're not getting to court anytime soon anyway. So get your money. All right, get your money now. And it looks like they just put up a link for you guys to, with regard to that, in the chat.
Okay, and it goes for rent through the end of December. So any 6 months that are owed from December backwards 6 months, you can get that through the rental assistance program if the tenant has already applied prior to the deadline. Okay, there's also rental assistance that's available for pre-COVID-19 cases. So we were just talking about the cases that were filed before March the 1st. And those are cases that are now being heard by the court. Even though you can't actually do the lockout until after January or later if it's extended, there's rental assistance that's now available to stop those tenants from being evicted. So if you have a tenant that falls into that category, get your rental assistance application in as soon as possible so you can get that money paid. Right. Any questions on rental assistance in the chat there?
No, there's one question. This is not on rental assistance. They just asked, they have a few evictions and they have court in January, but their claims included termination of term, but also past due rent. Will the courts throw out the money judgment? If you didn't send the hardship repayment notice, yes. My suggestion is send that now before you get there in January, and then you'll be fine.
Yeah, anyone that hasn't sent a hardship repayment notice, the money is owed, get those notices in as soon as possible because you will not be able to collect the rent without it. So make sure, I can't stress it enough, how important it is that you get that notice in. And what's going to happen, what's been happening, what's going to continue to happen is the tenant attorneys are looking for any technicality to get your case thrown out. So you need to make sure, you had to do this before, we had to make sure everything was done right. Now it's even more important that things are done right because they're going to scrutinize every single case to make sure all your I's are dotted, your T's are crossed. And if you haven't done everything exactly to the letter, your case is going to get thrown out.
And they're helping. They're helping to write these programs. The tenants attorneys are involved with the diversionary program. They know everything that's going on right now. They're involved with it. They're part of the reason it's getting passed. So trust us when we tell you that they're experts on this as much as we are.
Yeah, so every case is going to be scrutinized. So you got to make sure that you did everything right or you will not be able to evict a tenant and you will not be able to collect your money that's owed. Okay, very, very, very important that you do everything right. Okay. Any other questions that you see there,
No,
Janelle?
that's it on that. No, we're good. On to the most confusing topic.
Okay, if this isn't confusing enough, I want to talk real quick about lead paint. So as of October the 1st, the new lead paint laws went into effect. What you have to consider with the lead paint law is because it's being done on a rolling basis depending on the zip code that you're in. So various zip codes go online over the next 2 years. So the first thing you need to do for every single property that you have that was built before March of 1978 is to see when your property's zip code comes online. So I think there's 11 of the zip codes started as of October the 1st, 2020. More of them will come online as of April 1st, 2021. More than as of October 1st, 2021. And finally, the rest of them as of April the 1st of 2022. Okay. If your property falls within one of those zip codes, you absolutely need to make sure that you're complying with the lead paint certification law.
And it's for every single one of your units, regardless of whether there's a child living in the unit or not.
Okay. So as Janelle said, like under the old law, it only applied if you had a child 6 and under living in the property. Under the new law, it applies to every single property. Whether or not you have any children living in the property is irrelevant. It applies to every property. So the first thing you need to do is see where you fall within, your property falls within which zip code. So let's just assume for the moment that you're not within the zip code that's online yet, then you're complying with the old law. Hopefully you're all aware of what the old law is. Or what.
The zip codes is going in the chat now.
Great. There's the link to the zip codes, guys, so you can check your properties. Thanks,
Okay.
Brian.
It's also on the Hapco website. Can't stress enough to you too, as Hapco members, check their website. It's constantly being updated. There's a lot of good things happening. There's a lot of good information that's up there. A lot of good forms for you. New form just went up there today, which I'll talk about a little later on. Check often to see what's going on. Make sure you're in compliance with all the laws and the latest forms, leases, and all that kind of stuff.
Okay, quick question, Paul. Lynette, I'm going to get to your question. Just hang tight. It's a great question, but we're going to answer that in just a sec. Donald's question is, what does it mean? It doesn't apply to any homes built after 1978.
So no, if your house is built after March of 1978, you're good. You don't have to comply with the law. If your property is lead free, as opposed to lead safe, lead free meaning there's no lead in the property, as long as you get the lead free testing done, then you're okay with that as well.
You
Be
see,
advised,
that's good for life.
yeah, be advised though that the old lead free law required that you only had to comply with a certain percentage of properties under HUD guidelines when you certified it to be lead free, meaning you didn't have to test every single property. Under the new law in Philadelphia, HUD guidelines are still the same, but Philadelphia's guidelines require that every single property be tested.
Every single unit.
Every single unit, thank you. That means that a certification has to be uploaded for every single unit that you have to show that it's lead free. If it's lead safe, that has to be uploaded as well. You need to comply with the new law at the earlier of one of the following 3 events. This is very important.
Yeah, Ming, this is going to answer your question, so pay attention to this.
Okay, so you have to comply with the new law at the earlier of a lease signing. In other words, somebody moving into your property, which is what the old law required. At the inception of the lease agreement, when the lease started, you had to comply with the law. That's still there under the new law. However, you also have to comply now with under the new law on any lease renewals. And here's the kicker, you also have to comply prior to being able to renew your housing license. That's the hardest part. So if you haven't done the lead paint certification and uploaded that to the city's website, you will not be able to get a new housing license. If you can't get a housing license, you can't collect the rent. Big problem. And it's an even bigger problem with regard to lead paint certification, because under the lead laws, the tenant is entitled to all the back money that they've paid, meaning that if you haven't complied and given them, they move into the property and you haven't given them a lead paint certification and they started paying your rent and they pay your rent for 6 months, and then the tenant figures out you don't have a lead paint certification, guess what? Those 6 months that they paid you, you owe them all that money back. It's unbelievable, but that's the law. And you're going to get caught because you're not going to be able to get the lead paint certification. You're not going to be able to get the license because you don't have the lead paint certification. So really, really important that you comply with the lead paint certification law.
Okay, a couple questions, Paul. What if it's a month-to-month lease? Do they have to do it at the renewal every month? Like if the lease is renewing every month, is that a renewal that they have to get the lead paint cert then?
So great question. So the answer is actually yes, but no. Okay, it's yes because the law says you have to do it at the earlier of the lease renewal. It's no because the lead paint certifications are good for 4 years. So once you get it done at that property, even though the lease is renewing every month, you already have the lead paint certification, which is now good for 4 years. That 4-year period for lead paint certifications being good for started as of February the 1st of 2020. So if you had a child 6 and under that was living in the property and you previously got a lead paint certification, if you got it before February the 1st, that certification that you got is only good for 2 years. If you were lucky and you got it after February the 1st, that certification is good for 4 years.
And they're all going to be good for 4 years going forward for the new ones. If a lease is up for renewal before the zip code requirement kicks in, then you don't need to do it until the zip code requirement kicks in.
Correct.
That's
Correct.
that. And then Lynette's question, she's asked a couple times, which is a great question, is what happens if a tenant isn't paying rent, but they're also not allowing the lead inspector in to do the certifications.
Yeah, that's a
On that, how about the health department? He's finding it.
okay. If the tenant refuses to let, this is right off of L&I's frequently asked questions. If the tenant refuses to let the landlord in to conduct a lead dust wipe test, you must contact the tenant in writing via email or postal mail. Postal mail?
Regular mail. But we suggest you do that certified, so you have proof. At least proof of mailing, at least a little white paper.
A copy of this written notification, along with verification that the tenant received it, must be submitted to the health department. So you just have to sign a verification saying that you sent it by postal mail or email, and provide proof that you actually sent it to the tenant, and then you won't have to actually do the inspection.
Okay, and then you should be able to file. Great.
The key word there is should.
We haven't seen this happen yet. Obviously, this all went online a month ago, so we haven't seen that situation yet, but that's what if it's right on their website, you should be fine.
Any other lead paint questions?
No, that's it on there.
Okay, there is a lead paint addendum that you should have your tenants sign, a copy of which, again, is on the Hapco website. Download that addendum and have your tenants all sign the addendum. The addendum covers all the different laws. I tried to make one addendum that covers everything. So even if you have a property that it was built after March of 1978, have your tenant sign the addendum, because there's other laws that covers that you still must comply with, even if your property was built after March of 1978. Okay, so make sure all your tenants are signing that addendum before they move in.
Or at renewal time.
Yeah, or at renewal time, correct.
Okay, couple of questions here. Do you have a form for the lead advisory that is now required to give the tenants? I assume you mean the tenants. If you're talking about the addendum, excuse me, that Paul was just referring to, it's now on Hapco's website. If you're talking about because the tenant won't let you in, we don't have a form for that. You just have to give notification to the tenant. Samantha.
Yeah, I was just have to notify the tenant, and then when you upload it, you just have to basically say, this is what I did. So I hereby verify that I sent the tenant notice on such and such a date, a copy of which is attached here too. Upload that with the copy of it, and you should be good to go.
All right, Samantha's asking, I'm lead certified. Am I allowed to do my own properties? Absolutely, if you're certified. It has to be someone who is certified, though. It can't just be your maintenance personnel if they haven't gone through the training and the certification, gotten the certifications. And that's it. No questions. Oh, wait, one more. It says you have to have a lead advisory form with the certificate of suitability. I think that's just your lead paint cert. I don't know what a lead advisory form is. Do you, Paul?
It's lead paint certification, and have them sign that addendum, which covers everything that you need to comply with.
And that's on Hapco's website now, the addendum.
Yes.
Okay, that's it.
Okay. That's all I have for today. If there's any other questions, if
No, I
not,
think we did good. 45 minutes today. Not too bad.
all right. Thank you all for attending, and look forward to the next call when City Council passes the next.
Thanks, guys.
Take care.
Everybody, so you guys know, this Zoom event will be on our website soon, just so you know.